talking to you, Kaylin.
Joe's still sitting in his car having his breakfast.
Hi, Anna.
Hi.
That's why you're wearing that mask, so you can make faces at me without me seeing it.
Oh, don't worry. Her eyes will tell you what she's thinking.
Professor Bagley. Yeah, you're good even after that. We used to have.
Joe's been here a while, sitting in the car. He's been hanging out in his car.
At 9 o'clock.
We're sorry.
He was.
Welcome to WebEx.
Here's what he was best at. How many of you told you this, Jeff?
Enter your attendee ID number, followed by pound. If you do not know your attendee number, press pound to continue.
Oh, no, he was gone, but he got his.
Well, I didn't know that was an option, John.
I know.
Thank you for letting me know.
Keep that in your mind, back in your mind.
Wait a minute, I went to high school with him. I just didn't remember.
Yeah,
Now.
his attorney called me and talked at length about this guy, so I feel like I'm not.
The next time I'm in Utah,
Yeah. Your commitment
I would love to.
from the parking lot of Butter. Hi, ladies and gentlemen. We are ready to get this meeting of the Tennessee Real Estate Commission, June, what is today, the 8th or 9th? Thank you, the 9th. We're going to have this again, Anna, where I'm not, you're talking to me and I can't read your lips or see them. So.
Okay, if I'm speaking.
Okay, thanks. But you said the 9th, right?
Yes.
Okay. Meeting June 9th, 2021, meeting of the Tennessee Real Estate Commission. Let's let our Executive Director, Caitlin Maxwell, read the public disclaimer and then call the roll, please.
One quick note, we are on WebEx audio, and so when you are speaking today, make sure that your red mic lights up so that you can be heard. And then if you're not speaking and you do not want to be heard, just make sure that you're not close to your microphone during breaks and that sort of thing. Okay, now that we've gotten that out of the way, notice of the June 9th, 2021 meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since August 26, 2020. Additionally, this month's agenda has been posted on the website since Friday, June 4th, 2021. And now I'll call the roll. And the other good news is now that we're in person, this will be the only roll call unless there's a close vote. Commissioner Joe Begley. Commissioner Jeff Diaz.
Here.
Commissioner DJ Ferris.
Here.
Commissioner Marcia Franks. Commissioner Steve Gwynn.
Here.
Commissioner John Moffitt.
Here.
Commissioner Joan Smith.
Here.
Commissioner Stacy Torbett.
Here.
Chairman John Crease.
Here. All right.
You have quorum.
Opinion of the chair, we have a quorum. And so at this point, we'll proceed with the meeting and ask Commissioner Torbett to lead us in the invocation. And following that invocation, if you will stand, she'll also lead us in the pledge to the flag.
Dear Heavenly Father, I thank you so much for the opportunity to be back here in person. I thank you for the health and safety of everyone traveling to get here. I ask that you bless our efforts and help us to honor you with our words and actions and give us wisdom and discernment in the decisions that we make today. In Jesus' name, amen.
Amen. Thank you, Stacy. All right, you all were emailed the agenda or proposed agenda for today's meeting. Are there additions, deletions, corrections, or is there a motion to approve the agenda as it was submitted?
Motion to approve.
I have a motion by Mr. Diaz, seconded by Ms. Smith, that the agenda be approved as submitted. Any discussion? If not, if you're in favor of that motion, please vote aye.
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 Ha, see, we get to do it all at the same time now. I know it's a little bit different. Those opposed, vote no, and the motion passes unanimously. Next up is to approve the minutes of our Jackson, Tennessee meeting. You also were emailed those. I hope you've reviewed it. Any corrections or additions, or is there a motion to approve the minutes of the May 7th meeting?
Motion to approve.
Mr. Gwynn makes a motion to approve it. Mr. Diaz seconds that motion. Any discussion? I hear none. Those in favor of that motion vote aye.
Aye.
Those opposed, no. And the motion passes unanimously. Next up is an informal appearance by someone identified as Candidate A on my agenda.
We are looking for Mr. Daniel and his affiliate and his principal broker, Larry Willard.
Oh,
They were planning to attend via WebEx.
A. What's Mr. Willard? Is that right?
Willard.
Willard,
That's Larry Willard. What's the affiliate?
Dontavius Orlando Daniel.
Online.
Present.
Who said that?
Larry Willard.
All right, Larry, is Dontavius with you as well?
He's not.
Yes, I'm present.
We have both of you online. So
Yes.
what's about to happen, Mr. Daniel, Mr. Willard, is our executive director will give us a little background about your situation, and when she's finished, Mr. Daniel, I'll ask you to tell us what you would like for us to know, what you think is important about how you got in the situation you found yourself in, what you've been doing, what you'd like to do, and anything else you think might be helpful to your cause. Following your comments, commissioners will be allowed to ask you any questions they would like to ask. And following their questions, we'll go to Mr. Willard, and Mr. Willard will ask you to tell us why you'd like to have Mr. Daniel affiliated with your firm. Do either of you have any questions? If not,
No.
okay, fine. If not, Ms. Maxwell will give us a brief synopsis of the situation. Caitlin?
Hey, we have applicant Dontavius Daniel and his principal broker, Larry Willard. Mr. Daniel has taken the Tennessee Real Estate Affiliate Broker exam. His principal broker was first licensed in 2006 and became a broker in 2015. The firm is Caldwell Banker Barnes, and a summary of the criminal and disciplinary sanction is theft under $500. Mr. Daniel's statement and a letter of recommendation can be found on your iPad.
Before we go any further, Caitlin, typically these two would appear in person, but the state at this point has asked for us to provide WebEx access as well.
That's correct. I would presume for the next couple months we'll be giving candidates the option to attend virtually.
Perfect. All right, Mr. Daniel, could you give us your version of what happened, when it happened, how it happened, and anything else you'd like for us to know?
Yes, sir. Can you hear me okay?
I can, thank you.
The incident happened in 2016. I was at a local retailer, Walmart. I went in to do some shopping. What happened was I was looking for a gift for my mother. When I found the gift, it was about, the value of it was about $35, $40. When I found it, I put it in my cart to show it to my sister, who met me there at the store. When we looked at it, we continued to browse for things around the store. When we decided we were ready to leave. We weren't going to get it. We were close to the front of the store, so I was going to just hand it off to one of the employees there. Well, at that time, it was busy up there, and I didn't really see anybody. So I went on to, it was a self-checkout line. I went to check out my items that I actually did buy, and the item was at the bottom of the cart. So I really wasn't able to see it underneath all the stuff that I had in the cart. When I finished paying for the items, I went through to walk outside, and that's when the employee from Walmart stopped me and said that I'd been caught shoplifting because I didn't pay for the item when I was in the checkout line. I explained to him that I didn't realize it was still there. It was my mistake. I meant to hand it off to the employee that was working the self-checkout lines, but it slipped my mind. He told me that, that wasn't an excuse to walk out with it. I offered to pay for the item just so I didn't want to have any issue because I was able to pay for it. He said that once I was headed outside, that was considered shoplifting, and they would take the next steps forward. So that's pretty much the story of what happened there.
Commissioners?
Chairman.
Jeff?
Why don't you describe for us, once the decision was made to call the authorities, what was that interaction like with law enforcement, and what was ultimately decided?
Well, when they decided to call law enforcement, I asked them if that was absolutely necessary, as I was offering to make things right, because I honestly was not trying to do that at all. And they explained to me that it's company policy. There is, there's no wiggle room for that. I explained to him that, if that was the case, then I was not going to continue, trying to incriminate myself. I apologized to the employees. Once the law enforcement got there, I talked to them for a little while. He said that, he sees things like that happen at that Walmart. They do call them quite often about things like that. At the time, I didn't really understand, the reasoning in which, I couldn't just either pay for the item or just leave the item there. But at the same time, as a manager at my current employment, I totally understand the policies of the employer. So it was, I guess, an eye-opening experience, but of course I did accept that, I did make a mistake. So I figured I'd, go ahead and take the punishment that came along with it.
Questions? So, Mr. Daniel, one question. In your information you sent to the Real Estate Commission, you talked about expungement. Have you had this expunged or in the process of doing that?
Well, they when I talked to the court system, they said that in order to have it expunged, it has to be 5 years after the end of the sentence.
Oh, is that, will that happen? Is that what you expect to have happen?
Yes. As soon as that time is up, I will have it expunged, yes.
I want to ask our legal counsel one quick question. If he were to come here next year and it had been expunged, he wouldn't have to come here next year. Is that correct?
That's correct.
After 5 years and
yes.
With an expungement, okay.
After the time period and all of the documents are completed, signed by a judge, he would no longer have to appear.
All right, thank you, Ms. Matlock, and thank you, Mr. Daniel. Any other questions for Dontavius before we move on? All right. In that case, Mr. Larry Willard, you're his proposed broker. Would you give us your rationale for wanting to sponsor him with your firm?
Well, I talked to Dontavius briefly when we had an interview. Found out about this through the email. Talked to him since then and explained to him that being a realtor and bound by the code of ethics, that we have fiduciary responsibilities much greater than a mistake and leaving something under a cart when representing the public. I teach the code of ethics at my office meetings. We just had one yesterday again and went over it until they're blue in the face, although they still make mistakes. I truly believe he's employed right now at a local hospital, and I believe he can turn things around. Whatever actions or disciplinary that the commission advises, I'm sure him and I will fully accept that. If it's a year that he must wait, I'm sure that that's something that can be done also. But I will put my arm around him and make sure he's a good real estate agent and providing great services to the community. Have him involved with some of our company community activities as well.
All right, Commissioners, any questions for Mr. Willard? So, we, Commission, if you're ready to vote, we'll accept a motion, but we don't have to wait a year to get this expunged. That might be your preference, but it may be that you have enough confidence in Mr. Daniel and Mr. Willard that they can get this job done right now.
I move to approve this applicant to proceed immediately.
I've got a motion by Mr. Diaz, seconded by Mr. John. Oh, was it DJ? No. Okay. So the motion on the floor right now is to allow Mr. Daniel to proceed to get his real estate license. If you're in favor, is there discussion on the motion? Let's check first. If not, if you're in favor of the motion, in a moment you'll vote yes, and if you're opposed, you'll vote no. Last call. Any other discussion? All right. If you're in favor of the motion to allow Mr. Daniel to proceed to get his license, please vote yes.
Aye.
Aye. Or aye. Aye. Please vote in the affirmative. Those opposed vote no. The motion passes unanimously. Mr. Daniel, good luck, my friend. Make Mr. Willard proud.
Thank you. I appreciate it very much. Thank you.
You're welcome to stay and listen in the rest of the meeting if you'd like, by the way. Or you could be doing something more productive somewhere else. Thanks, guys.
Thank you
for coming in.
Thanks. I appreciate it.
All right. Next up is Mr. Featherstone from Memphis. And let's talk about procedure here for a minute. Caitlin, do you have anything to add to last month's? We had Mr. Featherstone. Or Anna, what are we doing today?
I'll turn that over to legal. They have done research on the case since our last meeting.
Hey, just catch everybody up from last month.
Okay, just as a brief refresher from last month, Mr. Featherstone appeared before the commission to be considered for licensure. There, we had a discussion about the agreed order that was entered in 2011, and there were several questions that stemmed from that. So at the last meeting, we deferred this matter to this meeting to make a determination to allow us to do more research to figure out about the agreed order. There was a question about whether we could amend the agreed order. Specifically, I think it had to do with the civil penalty and what exactly Mr. Featherstone would or could be reinstated as. I think there was a question of whether it was going to be an affiliate or a broker. And so based on the conversations that we had around the agreed order, stipulated disposition, I have spoken with Mr. Featherstone and spoken with other individuals, and I can give you kind of an update of what was determined by the legal department. So I think it was Commissioner Ferris that was asking the question about the matter of the civil penalty because he was concerned that it was outside of the 10-year look back, which this matter is outside of the 10-year look back, but it's an order that has been presented by your commission that has not been satisfied. So if we were to ignore the order after 10 years, it would kind of not make sense for anyone really to fulfill their consent order duties past that amount of time. I do believe that it is up to the discretion of the commission to make a determination of whether you would like to reinstate him as an affiliate broker or as a broker. I'll let you make that determination. As far as the civil penalty amount, I spoke with Deputy General Counsel Mark Green, and we again looked into this, and we haven't really seen an incident where the matters of an agreed order were being looked to change. So the agreed order is a lawful order that's been entered in this specific one by our attorney here. It was signed by the chairman and Mr. Featherstone's attorney at the time. So I do believe that you have the discretion to amend the order, but I would say with this caveat that it could potentially have issues further down the road, as this was an order that was entered in by a previous real estate commission. If you were to amend their order, I think it would maybe probably open the door for an individual that has an order in the future to come back and see if their order could be amended as well. And I'm not sure. I'll let the commission decide and discuss that question, but it might be something that you want to consider carefully.
I recall, it seems to me that Mr. Featherstone was going to go back and see if could prove he'd made payments, and the state was going to check to see if they'd received payments. Did anything come of that?
No, we have not received any payment from Mr. Featherstone or any of the education information that was listed. We don't have evidence or proof of that. The other thing I meant to mention beforehand with the civil penalty, since it is a higher civil penalty, I do think that if that was the commission's intention, it could be paid in installments over a payment plan, if you would like that to be an opportunity to afford Mr. Featherstone.
So, Featherstone, I'm going to get to you in just a second, but in the agreed order, there were three conditions. And this is on page 15, if you're looking on your tablet. A 2-year suspension, or until all these three terms have been satisfied. 16 hours of continued education times 3 different course titles, and a civil penalty of $5,000. And at this point, the state's position is none of that has happened yet.
Correct, only but for the suspension being more than 2 years.
Mr. Featherstone, do you agree that's true, that no payments have been made?
No, sir, no payments have been made, but until I was here the last meeting, I had never received a copy of that order. Now that Mrs. Madlock has given me a copy of the order, I understand the order completely. So I appreciate y'all allowing me to come back, but I understand the order now. And if I had understood that in advance of me coming the last time, I would have had it satisfied or told you what arrangements I had made to satisfy it.
Oh, maybe we can handle this quickly. You agree that these terms have to be satisfied before your license can be reinstated?
Yes, sir.
And you're prepared to do that?
Not this moment, but yes, I can do it.
And the state has offered it. It sounded like to me that you might be able to make that $5,000 payment over a period of time. Would that be your preference?
Yes. Yes, sir.
And is the question today, if Mr. Featherstone satisfies these requirements, what license does he qualify to be reinstated?
Correct. And additionally, whether he is to retake the state and national portions of the exam and completion of the pre-license education.
So for purposes of this commission's discussion, what do we need to answer? Are we going to make him take state and national portions again? Are we going to make him take pre-licensing courses? Are those the two questions?
There are three questions.
Okay.
Whether he is going to have to take both the state and national portion of the exam, whether he will have to complete the pre-license education, and what license status he will be eligible to receive, if it's going to be an affiliate broker license or a broker license, which is the last license he had previously.
Does the agreed order speak to that?
So the agreed order does not clarify, mention what he can be reinstated as. So that is something that I believe is within your discretion to make a determination.
Mr. Featherstone, to help us in our discussion, could you just tell us briefly your real estate career history?
Yes, sir, and I got a resume that I would like to pass out to y'all if that's possible.
We'll let that happen, but let's just hear you talk. Like, how long were you licensed before you had your license taken?
I had been licensed as an affiliate for 2 years, and I had been licensed as a broker for 30 years. I had been licensed 32 years and never been before the commission before. So I had 32 years that I did everything correct. I had one thing that happened, and because of my personal things that were happening in my life with my wife and my son's health, I just could not keep all the balls up in the air. So I said, let me just park my license for a moment, give me time to work back through my personal issues, and be able to come back strong. So what I'm asking is for another chance to get back out here and do the things that I have been able to do well.
Hey,
I also got my principal broker here with me today, Mr. Harold Moore. So he's here with me also.
Boss, would you mind getting those resumes? And I noticed, Jeff.
Ms. Mallock?
Yes.
If we can go back in time here to Wayback Machine, if the conditions of the order had been met, let's just say at the time, like 2013, the conditions of the order had been met, his license would have been reinstated at that point. Automatically?
I think so. That's the only issue is it's not written anywhere in the agreed order. So that is unfortunately kind of a vague issue that we're probably having right now. The same thing is it doesn't explicitly state. But I don't think because it doesn't explicitly state that, he would be ineligible to come back as a broker.
Eligible?
I don't think he would be. I think
You
could.
You think he could?
Yes.
Okay. Because that would be just reading the order, that would be my thought too. The license he gave up would be the license he gets back.
Right. But that information is not provided.
Okay, so commissioners, I think we've got one part of this puzzle solved. Mr. Featherstone says he'll meet the terms of the agreed order. So we've got to make 3 decisions, and I'd like to do them one at a time just so we keep them straight. And I'm open for a motion or further discussion before a motion, but first, should Mr. Featherstone have to take the state and national portions to get his license back? Steve.
Question, is he asking not to do that, or have we heard from him really what his ask is? What is he asking us to do?
Featherstone, you want your license back, right?
My understanding that I could get my license back once I met the terms of the order. And when I had communicated with commission before I came the previous time, they had sent me an email, which I got a copy of if you want to see it, saying that we have approved you through the lawyers at the commission, and all you need to do is come before the commissions and bring your principal broker. And that's why the last time I was not aware of, anything, because I have received that email saying that's all you need to do.
Well, we hope here shortly to give you a path to get your license. Okay.
Yes, sir.
That's what the votes will help dictate what that path is. So, should Mr. Featherstone? Here's the first question: is should Mr. Featherstone have to take both the state and national portions of the real estate license test? Commissioners, and there's no right or wrong answer at this point. We're just discussing it. Jeff?
Well, I feel like that in the intervening years, the laws and the regulations and such has changed to a point where it might help him in his future practice to have, once he's taken the pre-licensing courses and things like that, to go ahead and test. I mean, our objective here is to protect the consumer. And I think having him take the test again just to re-verify his mastery of the material, I think would be to the ultimate benefit of the consumer.
So, would you like to make that a motion?
I would make that motion. I move that he be required to take the state and national portion of the exam.
Was there a second? Steve Gwynn makes a second motion.
You said in there too the pre-licensing, so you're adding that together.
We'll come back to I'm going to keep them separate all the way. That'll be the next one. So the motion on the floor made by Mr. Diaz and seconded by Mr. Gwynn, if passed, would require as a condition of Mr. Featherstone getting his real estate license to retake or to take the state and national portions of the Tennessee real estate licensing requirement.
Sir, would that be just like starting all over as a new agent?
We'll see how this goes, but it would be. If you had to take both portions, it would be.
Or would that be taking the broker's test?
That's a fair question.
Because it said reinstated. Reinstated mean I would go back as a broker. But if I got to go back and take the state and national test again, then I would just be applying like a brand new agent.
So the third question we'll have to answer is what license status would you have? So I think how that vote comes out will dictate which test you have to take. So if you'll stand by, I think we can get to that answer. Is there more discussion on Mr. Diaz's motion?
Chairman, I've got a question.
Yes, Mr.
Will, perhaps this is regarding item number 2 or question number 2. I am of mind to follow the council's recommendations to stick with the order that was put up previously by the prior commissions. And by doing any of these, will that, if we say yes on all of these questions that we've put, that the chairman has posed, to take the exams, to do the pre-licensing, and then determining what license status, is that going to be in any way contrary to the order?
No, it won't. So the reason that the education and the testing is coming into play again is we receive at least once a month a request for an individual to reinstate their license beyond 1 year. So the rule says if your license has been expired longer than 1 year, you are required to reapply, retest, and satisfy any education requirements. And so that is why that's being brought before you right now, especially since the last time that there was a discussion about that would be in 2010 or 2011. So I don't think it would be contrary to the order. The order is what is going to be, if we were to look at it, get him back to question number 3, well, whether it's going to be an affiliate or a broker. But we'll need to know if he's testing or education for the rest of his application process. That's required of everyone.
Okay, so are we going to be, the order says 16 hours of ethics, 16 hours of property management, 16 hours of contract writing. That's really vague, in my opinion.
So typically when we assess education to a respondent, we don't tell the only courses that are very specific are the core course and the principal broker core course. Any of the other courses, we kind of generally say a 4-hour contract course, not a specific course.
Okay.
So it just needs to be 16 hours. How many courses that is up to him.
Okay.
That fall in that category.
Okay. but we're not going to be putting more hours. Well,
Perhaps.
perhaps.
Perhaps that question too, we might.
Yeah.
We'll see.
Okay.
But all these votes are predicated on the fact that Mr. Featherstone has agreed to complete the terms listed in the agreed order. These are just making that assumption. How's it going to go from there?
Yeah, and based on what counsel just said, that it's by statute that if somebody's beyond a year.
It's by rule,
By rule.
yes.
Yeah. Okay. Thank you.
And I'm gonna.
Sir, can I?
1 second.
Okay.
So, in terms of being able to sit for the state and national portion of the exam, I think the pre-licensing course, is that required in order to get into the exam, or can you just sign up and take the exam when you feel like you're ready?
So there's two answers to that question. If you are just starting out as a real estate agent, you've taken no education previously, then the pre-licensing courses are your entry to take the test. The provider sets you up to take the test after you've passed the course. For anybody that is expired over 1 year, we look at their education, determine if they meet the pre-licensing education, because that's evolved. So, what the requirements were in 2010 might be different than what they are now. Now it is 90 pre-licensing hours for an affiliate and 120 for a broker. And for the broker, it must include the office broker management course. So for retest, we set them up once we verified that they meet the pre-licensing education requirements.
Does experience also play into that decision as well?
So for a broker, it does. For a broker, you have to have been licensed for 3 years in order to qualify for that test. For an affiliate, we just look at the education.
Okay. So if you were to, hypothetically, first of all, could that assessment be done for him as a result of the decisions here? Whether he needs to sit for the pre-licensing courses or not?
Yes, so I can tell you what we have on record. He would obviously meet the 3-year requirement for the broker, but as far as education goes, on the record, which if he has anything different, we would be open to reviewing that. But I show a total of 100 hours of education, 2 pre-licensing 30-hour courses taken in 1979 and 1976. So a total of 60 hours for the pre-licensing. And then the rest appear to be in, general elective courses.
So the record as it stands, what would your recommendation be that he do for going forward?
Well, I think it depends on if it's broker or affiliate broker. So broker requires 120 pre-licensing, so he would need probably the office broker management course if he was going to apply for that license. And then if he was applying for the affiliate license, we would probably need the 30-hour course for new affiliates, because we have 60 hours of pre-licensing right now.
Any other questions or discussion? Steve?
This is a question, I think, for
I'll let Director Maxwell make that decision. I do know if an individual allows their license to expire more than a year and they've had their license in a long time, you would lose your grandfathering status for continuing education. So I'll defer to Director Maxwell with exactly what the typical education requirements would be for a broker at that point.
It would be the same. We would review the education file and we would determine if they met the current. So part of the rule says meet the current education requirements. So we would review it and see, and if they were a broker, they would be able to retest for broker because they would have probably already met that 3-year experience. And then we would look at their education history to determine if they met either the 90 pre-licensing for an affiliate if they were testing for that license, or the 120 pre-licensing required hours for a broker. I would say that's probably up to the commission because, you know, a lot of times when we authorize education now, it's not for credit. So like a lot of times when the commission gives penalties currently, you know, you'll say the principal broker core course over and above any required education. So I think that's ultimately up to the commission as to whether they want to allow that education to count. Based on this, we would just need 20 hours to qualify for the broker. Additional.
Caitlin, what was the 30-hour class you mentioned earlier?
So in order to qualify to sit for the broker exam, you must take the 30-hour office broker management. There's also a 30-hour course for new affiliates.
And that has ethics and core and stuff in it, I presume?
The 30-hour course for new affiliates, I think, is a whole gamut of getting you ready for taking the exam and being licensed.
Commissioner, can I amend the motion and
substitute motion, whatever you'd like to do.
Substitute motion. Have 2 or 3.
Sure. As we're talking about this one topic right now, state national tests.
I'll stay off that.
All right, John.
I'd like, Mr. Featherstone, do you want to be a broker or an associate broker?
I would like to be a broker, sir.
Okay.
Because, you know, if you look at my resume, I've done plenty of things real estate related. And I've had every course the University of Memphis offers in real estate. You know, I've had core real estate courses. I had to offer broker management course before I applied for my broker's license. I've had all of that. And, you know, it would be just like me starting back over in the first grade. You know, repeating courses that I've already got university credits for. So that's what I'm asking, if possible, not to make me go back and repeat courses that I got actual university credits for.
I think the issue that is a sticking point for me and probably a lot of other commissioners is just the amount of time that has lapsed since this order was put in place. And I understand you didn't get the order, you didn't know what the requirements were, but it has been over a decade, sir, since you practiced real estate, and things have changed. And to assume that your past experience it hasn't sat on the shelf and expired a little bit, I think is too far for me to go when the purpose of this board is to protect the consumer. So we need to make sure that your information and your training is current before we unleash you in the marketplace with a license to do real estate deals. So I think that's the sticking point for me, sir, is just making sure that your information is current. Your resume speaks to that you're able to do that, but we have to have that last safeguard for the consumer, in my mind. Thank you, Mr.
Yes, sir. But let me ask this: where do I go to take those courses at?
Well, let's see how the vote goes, Mister. Don't get ahead of yourself.
Okay.
All right. Let's see what we have to do. Are there other comments?
One.
Yes, Joe.
On your resume, this is a little bit, but your resume, these construction projects, do you have a general contractor's license?
Oh, sir, I was a developer, not a contractor.
Okay.
You know, I've developed housing for low to moderate income for years. Okay, and you can see some of those results, and because my people go through home buyers education and all that, when they get into a home, they take care of them and they don't go to foreclosure. So it's a proven track record that through the Home Ownership Foundation, I have perfected a system that works.
All right, Mr. Featherstone, be quiet for a minute now. Other comments from the commissioners?
Call the question.
Well, let me admit, I have a comment.
Okay.
So I totally, completely agree with Ms. Matlock that we can't or shouldn't go back and change an agreed citation from another commission, because I think it would open a door that would never get closed. But with that said, when I read that agreed citation, it didn't give Mr. Featherstone a certain amount of time to get it done. Maybe that was written poorly, but it sounds to me like, when I look at it, that the agreed order said before you can get your license back, you've got to do these things. It didn't say you have to do them in 2 years or 3 years, or you have to take the test over again or not. I understand, and this is just a counter argument to Jeff's argument, which is a good argument. But when I read that agreed order, I don't want to change it, but I don't want to read more into it than is there. So my interpretation of the agreed order is that if Mr. Featherstone does what the agreed order required him to do, that he should be able to get a license back. And it doesn't put conditions on how to get that license. It doesn't say you have to test again. It doesn't say what type of license it is. So in my opinion, on this first motion, I'll probably vote no against it, because I think the agreed order is what I have to make my decision on, not the good logic that Jeff uses to say, well, you need to have more education. Those were my comments. What it's worth.
Can I just make a comment about the fact that the license has been expired since 2010? And I just think potentially it's starting a bad precedent against the rule if we allow somebody that expired in 2010 to just gain their license back.
Did it expire because it was suspended?
Well, it expired because it expired.
Well, I got it, but
yeah,
because a previous commission said you don't have a license anymore until you do these things.
Well, the license expires when you don't meet the requirements for renewal.
All right. Other questions?
Call the question.
Okay, Mr. Yes. The motion offered by Mr. Diaz and seconded by Mr. Gwynn, if passed, would require Mr. Featherstone to take both the state and national portions of the real estate test in order to get a license, whether it's affiliate or broker, which is to be determined in question number 3. If you're in favor of that motion, you'll vote yes or vote in the affirmative. And if you're opposed, you'll vote no. All right. Anybody want a roll call vote? Let's try roll call vote. I have somebody that wants one. If you're in favor, vote yes. If you're opposed, vote no.
Commissioner Joe Begley.
Yes.
Commissioner Jeff Diaz.
Yes.
Commissioner DJ Ferris.
Yes.
Commissioner Steve Gwynn.
Yes.
Commissioner John Moffitt.
Yes.
Commissioner Joan Smith.
Yes.
Commissioner Stacy Torbett.
Yes.
Chairman John Grease.
Oh. Since that motion passed, and we're on to the second question. Should Mr. Featherstone be required to take pre-license education? Who would like to speak to that?
I'd like to make a motion that he takes the 30-hour new affiliate.
And not the pre-license courses. That's just to be clear, Caitlin, there's a pre-license course, or Ross, one of two, and then there's 30 hours follow.
It might make sense to have the discussion about broker or affiliate before you have the education discussion, just because I think that will determine what would be needed.
All right, so let's move to question number 3. Assuming Mr. Featherstone meets all the requirements of the agreed order and conditions this commission can put on him today, should he be allowed to have a broker's license, or should he have an affiliate broker's license? Jeff?
Ms. Matlock, is it your sense that had he satisfied the requirements of the order, he would have had his broker license reinstated?
Yes, so it states that the license shall be suspended for a minimum of 2 years or until all of the terms of the agreed order have been satisfied. And then it says the respondent shall pay a civil penalty in the amount of $5,000 payable prior to reinstatement. So I would believe you can read it both ways, but there's a strong argument it would be his broker license.
License being suspended was a broker license being suspended. So reinstatement, we're on safe ground to say the license being reinstated would be a broker license.
Right. I don't think that would be what's the word I'm trying to say? Yeah, that would be within the looking at the order. I don't think it would be something that I think it falls in line with the order.
That's you.
I'm gonna.
Okay, Steve.
How many hours is the broker management course?
30.
30. Okay.
Got the floor, Steve.
So I've got a motion that would be that Mr. Featherstone take the broker management course of 30 hours. That would get him on top of the 48 he already has to do, 78 hours, which is, in my theory, it's 75% of the way through to the 90 that you were mentioning before.
If he did that, would you be in favor of him getting his broker's
Yes.
license back?
Yes.
And so I'm going to take that as a motion at this point.
That is a motion.
Okay, is there a second to that?
Second.
Ms. Torbett seconds the motion. The motion, as I understand it, and I'll repeat more than I should, assuming Mr. Featherstone satisfies all the requirements in the agreed order, then this commission is in favor of allowing Mr. Featherstone to have his broker license with the understanding that before he gets it, he has to complete the 30-hour broker management course. That's the motion on the floor. Discussion on the motion.
Well, and I just want to say that's the minimum standard that he has to meet in order to take the exam. And I think everybody on the commission would agree, at least I'm going to say, that it's highly recommended that he exceed that to make sure that all of his information is current and all in his training is current. Just a comment.
Other discussion? Vote. Motion in summary says if it passes with certain conditions, Mr. Featherstone can get his broker's license. If you're in favor of that, you'll vote aye. If you're opposed, you vote no. I don't know that we need a roll call at this point. Let's try a voice vote. If you're in favor of the motion, please vote aye.
Aye.
If you're opposed, vote no. And that motion passes on a 7-1 vote. Mr. Bagley votes no. All right, now we're to the third question, and maybe we answer that. The question was, should Mr. Featherstone be required to take pre-license education? Commissioners?
I feel that. I think we
What's your motion then, Jeff? Motion out require Mr. Featherstone.
I'll make that motion.
Is there a second? We'll get to you, Caitlin. Is there a second? Steve Gwynn votes that, makes a second motion. Caitlin?
I think the last motion included the office broker management course, which is considered a pre-licensing course.
Broker.
For broker.
Okay, so there's no need to answer even the third question at this point.
I don't see the need to answer the third question. I think you answered it with your motion to allow him to test for broker after taking the office broker management course and taking and meeting the requirements of the education and the order and the penalty.
I withdraw my motion.
Okay. Motion is withdrawn. Anyone want to discuss what Ms. Maxwell just said?
I just have a question.
Yes. Yes.
Up to
So,
or is he going to have to pay that before any of this other takes place, or can that be concurrent with everything?
Right. So typically when we offer individuals a payment plan with a form of discipline, we are permitted to allow a payment plan for as long as 1 year, and the individual can choose like how much money they would like to pay. So sometimes for me, when I'm drafting a consent order, I will divide up payments, 12 payments over a year. But other individuals decide that they want to pay more in less intervals. So I think because of the severity of the civil penalty, it can be concurrent to what he is doing right now.
And I think the other part of that is typically if a licensee enters into a payment plan, they're given a certain time to comply with the payment plan, and their license remains in good standing while they are compliant. Now, if they become non-compliant and they're outside of the allotted time, that's when the action would be taken to the next step, such as a formal hearing in a typical current complaint.
Order would assume that all conditions have to be met before the license is reinstated, which would include full payment civil penalty.
Right. But I think also the order contemplates a time period of 2 years minimum. And right now what we're talking about is less than 2 years. So if we were making this decision like in 2010 or 2011, I would say yes, he has to pay all the money back at once. But I think requiring a licensee to pay $5,000 immediately would be unfair.
Yeah, no, that's not what I'm aiming at. I'm just saying before he can get his license reinstated, all other conditions satisfied, the civil penalty has to be paid in full, whether that's over 12 months or all at once.
No, so my understanding, and Caitlin can correct me if I'm wrong, is Mr. Featherstone would need to complete the 30-hour course, test for the exams, and complete the continuing education that is provided in the order, and then his license will be reinstated. The only outstanding portion at that point that we've talked about today would be the $5,000 civil penalty. So as Caitlin was saying before, if someone enters in the payment plan with us, their license is still in good standing while they're doing that. So if there were, what I would do in this situation is I would draft a document for a payment plan with Mr. Featherstone, have him sign it with all of the requirements and terms. So we're just waiting on the other pieces before the civil penalty. But
Testing, education, testing, license is reinstated, then payment plan for the penalty.
we can, but also those can be done simultaneously. So he can start paying on the civil penalty, ideally, if he wanted to, today.
The order says prior to reinstatement. So we're trying to keep with the order from prior commission. So respondent shall pay a civil penalty in the amount of $5,000 payable prior to reinstatement. And so if I'm voting, I'm acknowledging he's going to do all these exams and courses and the pre-licensing, and he's going to get a payment plan, and that $5,000 has to be paid before he gets a license reinstated.
I don't think that's what she's saying.
That's not. I know. That's not what she's saying, but that's what this says.
So
my understanding is that it's being met as long as he enters into a payment contract. So it's like it's being paid. It's been paid because he's agreed to pay it, right?
Right. So it wouldn't. So it says prior to reinstatement, which is true. Excuse me. You could have all of those requirements be satisfied prior to his license being active, but I do think there is an opportunity that those can be added concurrently. So if, for example, the commission often will issue a civil penalty of $1,000. And at that point, when we're making the decisions for a consent order, we will tell the person that they can either pay it now or they can do a payment plan. So I think that would be more analogous to the situation that's going on here.
I think that
for a payment plan.
Right. So I have the authority right now to do a payment plan for as long as a year. And those payments can be broken up into whatever amount that Mr. Featherstone wants to do.
Featherstone would.
Yes.
Question.
Yes, Steve.
Well, Anna, what kind of language do you have in your agreement that talks about default? So if he doesn't make the payments, does his license get resuspended? I just think we need to be crystal clear on this issue as we sit here today, because maybe there was a little vague language in this deal from 10 years ago, but we shouldn't fall back into any kind of vagueness. So,
right.
At least in my opinion.
So what I would do in that situation is I would include all of the terms that we include in our consent orders for a payment plan. That contemplates default, contemplates acceleration if the individual defaults on their payment, which means it's due immediately. It has all of those and those pieces in place and what will happen if you fail to pay at this amount at any time. So all of the things that you're thinking about are going to be included, and it's going to be very clear. It's the standard language that we use across all of our boards and commissions.
What is that language?
Let me pull up the information for you really quick. I'm going to pull up another payment plan.
I think the question is alt that and that.
Right. Okay. I'm pulling up
because essentially the order from 10 years ago, he defaulted on it, or otherwise we wouldn't be here. So I think we just need to be clear on going forward all the parameters of this, let's call it new deal, if you will.
Okay, so I'll just read this so you can know what information is usually included. So it states that first is acceptance. Respondent agrees that submission of a fully executed and dated copy of this agreement shall constitute acceptance. They further agree that submission of payment, whether in whole or in part, shall further constitute acceptance of this agreement. Grace period. Payment shall be made timely. Payment shall be made timely made if postmarked within 5 business days of the date the payment is due. Acceleration. Respondent hereby agrees that failure to remit any payment more than 60 calendar days following the date the payment is due shall constitute a default and shall result in the entire outstanding balance becoming immediately due and payable. Default. Respondent hereby agrees that upon acceleration of any outstanding obligation that is mentioned above, the issuance and/or renewal of any license issued by the department which respondent may hold shall not be issued and/or renewed until all terms within this agreement are satisfied. Modification. Respondent agrees that any modification to this agreement shall be made and agreed in writing by the parties. Also, respondent understands and agrees that the commission has the right to revoke respondent's license based on respondent's failure to comply with any term and provision within this agreement. Also, failure to comply with any term contained, including but not limited to making timely payments to any approved payment plan, submitting proof to the commission of meeting in any required continuing education courses shall result in the automatic suspension of respondent's license. If suspended, respondent's license shall be reinstated only when the default is cured and proof of the cure is received by the commission and respondent has fully complied with the terms of the agreement.
Okay, so let's hypothetically say that he takes the courses, passes everything. It takes 6 months from now to do that, and he enters into a $5,000 payment plan over 12 months, let's say, that starts at the end of, or when he gets his license, okay? And let's say he only pays half of that instead of all of it over the next 12 months. So we would have, when his license came up for renewal, he would owe that money, half of it, right? And we would not renew his license again. That would be our trigger point, correct?
So when an individual, essentially what you're talking about, breaches a payment plan, that is not usually a matter that has to come back before the commission because those terms are agreed upon in the document. So if that were to happen, his license would either be suspended automatically or revoked. So it's not going to be able to be renewed when it's in either of those statuses.
Got it. Okay. Thank you.
Yes, Jeff.
So the order talks about a $5,000 penalty, and then in the second part it talks about a $2,500 penalty. That's for the son. Okay.
Yes.
Okay.
It's delineated. The top part is for Mr. Featherstone Sr. The bottom part is for Mr. Featherstone Jr.
Okay. Thank you.
Okay, commission, staff, Mr. Featherstone. Here's what I think we've done, and we're finished with it at this point. The commission has voted to allow you to get a broker's license with conditions. You have to take a 30-hour broker management course. You have to pass state and national tests and complete those items that were listed in the agreed judgment. When all those events happen, you'll be issued a broker's license. So you didn't get everything you came here for today, but you got more than you might have. So do you, Mr. Featherstone, or is it Mr. Moore, is that right? Your broker?
Yes, sir.
Do you both understand what we've done?
Do you speak?
Certainly. Been here for 2 meetings and hadn't been able to say a word. We'd like to get him up here. Give us your name for the record. That'd be appreciated.
My name is Harold Moore, principal broker of Harold C. Moore Realty Company. I hold a GRI designation, CRB, CRS, and Realtor Emeritus. Billy Featherstone came to work for me, and the company was growing faster than I could handle alone, and he was my first sales manager that I promoted. I promoted him to oversee part of the agents that were in the company, and then promoted him to oversee the next 2 sales managers that came in, and he was essentially running the company. He liked not only a good understudy, but he became like a son of mine. And I really, really appreciate the opportunity of appearing before you, great commissioners and staff, to give my support, complete support to Billy Featherstone. We came to Jackson, Tennessee last month and here today. And I would specifically request that you all grant him his broker's license. That seems strange, my being the principal broker, not want him to come back under me as an agent. But I think that he earned the right to be a broker. And I would really love to see this great commission reinstate his broker's license with whatever requirements you put on him. Thank you very much for letting me
Thank you, Mr. Moore. We've created a path for that to happen. So I want to make sure that you understand he can have a broker's license. He's got some hurdles, some hoops to jump through, but it can happen. He doesn't have to start over as affiliate broker again.
Yes, sir.
All right.
I think I would appreciate him being granted your requirements and statement in writing, so that he would have to comply with them like 1, 2, 3 down the line, and the rule not change before and ask him to come back here again.
So, Mr.
Thank you all very much.
Miss Matlock and Mr. Featherstone have been in touch, and they have an open line of communication, I think. Is that the right way to say it, Anna? You're not mad at him, and he's not mad at you or anything. So, okay. So I think we'll get what you're looking for. And by the way, it's refreshing to see 2 real estate professionals in a suit and tie. We don't see that much anymore. People show real estate today in blue jeans and flip-flops.
Right.
It's a totally different time. Thank you, gentlemen, for coming.
Thank you,
We're going to
sir.
take a 10-minute
All right,
break.
bye-bye.
Oh, he has a question.
Yes.
Ms. Maxwell. Ms. Maxwell, what would be the difference in me starting new? Because if I could take the courses and then I had to take the test, well, that would be just like starting new all over, wouldn't it?
Well, you are getting 90 hours waived.
Ma'am?
You are getting 90 education hours waived based on the education that you had.
Okay.
So you're getting the 90 hours waived, but the rule does state anybody expired over 1 year must retest, reapply, and meet all current education requirements. So if you were starting anew, you would have to take 90 hours, be licensed for 3 years, take the 30-hour office broker management course, and then you would still have to either test for affiliate or test for broker.
Now, let me ask you this. Who is offering educational courses? Because I've depleted everything the University of Memphis has.
So I'll get with Miss Matlock when she sends you all the terms. We have all approved education on the website. So
looked at those, and the courses that is being required is not on there.
So I'm going to interrupt the conversation. We can take a 10-minute break and we can have a private conversation.
Okay.
So commissioners, we'll be back at what time?
Appreciate it. Thank you.
Thank you. It's 9:42 at 9:52 or 8:52, wherever we are. 9:52. Okay.
Okay.
I should get lucky.
Fucking somebody.
Trash can?
I found a trash can up here.
I got that.
John, I'm like, how come I have to go first all the time?
Billy.
On Saturday, I was up in Elmwood on the Caney Fork showing a property. That's pretty. Into Tennessee. States.
I don't.
Two ladies. They're best friends.
How much land do they want?
Really?
Yeah, incredible stories. I mean, you talk about grit. Yeah, it's a long way from LA.
Oh yeah.
It's a long way from LA.
It's pretty.
It's a pretty spot.
That's a beautiful. No, I lived in Mercer. I
You're
got
a
a lot of
Rutherford
free.
County native.
Hmm?
You're Rutherford County born and raised.
Yeah.
Okay. What part of that county?
I knew Murphy.
Basketball.
Oh.
California. Enforcement.
Oh my gosh.
And then it's got no wow.
All right, ladies and gentlemen, we're ready to get started back. Okay, we're going to get on to the Education Director's report. Mr. White.
Thank you, Mr. Chairman, members of the commission. Good morning. Welcome back into the building. I think this is our first time this year.
This year, how long has it been, Caitlin? 15 months or 16 months, something like that?
Dean.
So we're back and we'll move forward with today's education report. From last month, I had a personal best of 85, so we're down to 17 this time. So a little bit different report, and so I want to present to you today the education agenda. I have reviewed all the providers, the instructors in these courses, J1 through J17, and I asked for your review of those this morning.
Motion I'm looking for is to approve courses J1 through J17 based on the recommendation of the Education Director. Is there such a motion?
So moved.
Mr. Diaz makes a motion. Mr. Begley seconds that motion. Discussion. All right, if you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. There are 3 instructors that Mr. White is also recommending we approve. Any questions about those instructors or any comments, Ross, you want to offer?
Just clarification, there are 4 of them.
4, I'm sorry.
Offering those for
Moved to approve these instructors.
I've got a motion by Mr. Diaz, seconded by Mr. Moffitt, that the Education Director's recommendation be adopted and these 4 instructors be approved. Discussion. All right, then, if you're in favor of that motion, please vote aye.
Aye.
Aye. If you're opposed, vote no. The motion passes unanimously. All right, Ross, what else do you have today?
Thank you, Mr. Chairman. I
want to speak publicly about your growing family or anything like that?
I want to say just one proud note, but I had turned a new year. I had a birthday this weekend, and then at the same time, my daughter, Emily, who is a school teacher in Memphis, sent me a package, and she said, I want everybody to gather around the package. And there was a onesie in the package. It says, hello, Grandpa, Grandma. So I'm going to be a grandfather.
Congratulations.
Thank you very much.
All right. Caitlin, you have any onesie stories for us?
I do not.
Okay, just checking.
But I did get to see the onesie yesterday. So it's true. But I just had a couple updates for the commission. The first being that we are all set for Arillo. Joan and Jeff will be heading to San Antonio. So hopefully we'll have a good update for the full commission at the July meeting. And then I also wanted to note, I have mentioned some ongoing issues with PSI, and we will be, PSI will be hosting a roundtable with all pre-licensing education providers before the next meeting that I will also be attending. And so I'm thinking that will hopefully iron out some of the issues that pre-licensing providers are seeing when they, as we kind of mentioned earlier, if you're an initial licensee, you take the pre-licensing course, and then the provider is the one that sets you up to take the test. And so since PSI has updated their system to allow the virtual testing, we've been having some issues with students, but then also with the providers setting them up. So hoping that alleviates a lot of the issues we're seeing. And just for the record, that's on June 23rd. So I'll have an update for the commission on that at the July meeting. And then just the last thing is at the July meeting, we are going to bring the 2022 meeting dates for everyone to review. So if you have a calendar, bring it so we can check the dates and make sure we go ahead and set the calendar for next year. That works for everyone.
Questions for Caitlin? I have one thing. On your executive director's report, there's a page about licenses. I don't know if the commissioner's got a chance to. It shows that in June there were 39,350 active real estate licenses. Those were individuals, not firms. They're not retirees. They're not agents whose licenses have been suspended because of errors and omissions. Is that correct?
That's correct. Those would be under the suspended column at the bottom, and then retired is also broken down.
So, I mean, we're easily, I think, over 40,000 active licenses in the state.
Yes, including firms. I would say we're somewhere around 44,000 active. And then with retired, you know, we're over 50.
That's an unbelievable number in my mind, and I think it's the highest I've ever seen it. It's just amazing the number of people that this commission and staff, particularly the staff, are handling. These, and not, this doesn't count inquiries or what do I have to do or where do I go to get my education. These are active licenses. And you all may be getting phone calls from brokers or licensees or the public, but I'm getting nothing, Caitlin, which is perfect. It speaks to what a good job you and your staff are doing, and I just want to say that publicly every time I get a chance.
Thank you. I've been tracking the initial licenses just to see, just look at any trends as far as how many are coming into the profession. And I can say that the staff is doing a great job. We're averaging 6 days for initial license time and 2.5 days of just work, which is a new metric that they've started tracking within the last couple of years. Essentially, that's the time where we're not waiting on anything. So if we get an application in and it doesn't have something, we can put kind of an action on it, reach out to the licensee, and then, so it's really tracking how long the staff have something. So
phenomenal. Now, just a follow-up question to that: are most of your staff working at home still, or what does it look like now from a work schedule?
Yeah, so right now we're on a business need to be in person, and so our staff right now come in once a month, and then as needed for business. Aaron is here today, and that's in addition to when he would come in for a business need. We're coming in to check the mail and assist visitors. There's really nothing that anyone needs to come down to the building for. If they have an application, it's honestly quicker to do it online because of the payment. If they pay here in person, there's a delay for when it hits their application, whereas if they pay online with a credit card, it's directly, we can work it immediately. So there's really nothing that you need to come down here for. But yes, and I think the staff really enjoys working from home, and we haven't seen any decline in service or work. Most of our staff are not here in Nashville, and so not having that commute every day is definitely an added benefit for them.
It's been a great job. Which reminds me, I meant to put on the agenda today a discussion about what a good job Aaron Smith is doing, and somehow it just slipped by. I forgot to get that on there. But
a little shout out to Aaron. Aaron is doing double duty. He is actually he was selected for the Commissioners Academy, which is for employees that are going above and beyond, and so he has his Commissioner's Academy today, and then he's also here. So
can you hear anything we're saying right now? Sleep back there? What's he doing?
There's no indication that he can hear you.
Probably just as well. Thank you, Caitlin. All right, any other questions for Caitlin or Ross before we move on? All right, we're to the consent agenda, which is relatively short. I have some cases that have been requested to be pulled out. I'm going to tell people, if you want to make a note of them, that there are 6 cases. So we'll get a motion to adopt legal's recommendation on the consent agenda, and then I'll tell you which cases to pull out of that, and then the motion will cover everything else. Okay? So you have on your iPad, is this an iPad? Yeah. Okay. an attachment that lists cases 1 through 50. Those cases each have a recommendation from counsel on how to dispose of the case. So is there a motion to accept counsel's recommendation on those cases? Mr. Diaz makes a motion to accept. Ms. Torbett seconds the motion. Now, here are the cases that commissioners have asked to be pulled. So if you'd like to make a list, there are only 6. Case 8, 12, 14, 15, 20, and 34. So the motion on the floor, as interpreted by the chair, is that all other cases are to be handled per the recommendation of counsel. Any discussion? If not, if you're in favor of that motion, please vote aye.
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 If you're opposed, vote no. And that motion passes unanimously. So now we're on to case number 8, the first of the 6 that we pulled. And I pulled this one for one particular reason. If you'll take a look at number 8. I think the analysis done by Shalina is fine. I have no issue with the recommendation. But I do need to have a discussion about the fact that this respondent had 3, maybe 4 files that were closed and flagged. And I've always been under the impression that if a file is closed and flagged, that if that person ever shows back up, the file will be resurrected or something will happen. So I'm hoping to get that clear in my mind today. Shalina?
Sorry. Commissioner. The close and flag on this particular case is because there were multiple complaints going back and forth between the complainants and this respondent previously, and they were merely closed and flagged because of the number of complaints alleging fraud. There was no merit to the complaints on either side.
So why wouldn't we have just closed them at that point instead of flagging them? That's the flag part's what I'm trying to understand.
I don't believe we just flag a complaint. It has to be closed as well as flagged.
No, but why flag these complaints, I guess?
In case that there were additional complaints that were legitimate because of this back and forth between the parties, where multiple complaints alleging similar types of conduct occurred, that's why they were flagged. It didn't necessarily need to be flagged, but just in case.
Typical closed and flag situation, we have somebody that didn't respond and legal doesn't think there's a chance we'll be able to get a response, so we recommend closing and flagging in case that respondent ever shows up, then we'll go back to that complaint. But in this case, there's no reason to go back to these. Okay. So the chair is happy to entertain a motion to accept counsel's recommendation on case number 8.
So moved.
Second.
I have a motion by Mr. Diaz, seconded by Ms. Smith, that counsel's recommendation be adopted. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. All right, number 12, Joan.
And I'm not sure. I read this one. I read this one a couple of times, and I'm just not sure where I am on this one. I think the main thing is, how do you make someone aware that when you post something on Facebook, whether it's a closed group or not, that it's out there forever? Whether it's did anyone else kind of just cringe a little bit on this one? So I guess my question is,
What did you cringe about the joke, or did you cringe?
I cringe because when you make a joke about someone and you have a professional, and you stand in a professional way, and you understand that you have a professional relationship, and you're supposed to be you're not supposed to be doing that. And here we are. And maybe I've carried myself in a different way that I shouldn't have.
But you're carrying yourself just like you should. The question is, do we have authority over how other people should?
Yes, and that was my question. That's where I went all around the rabbit hole. And I didn't know if that was something that TREC should respond to? Should a letter of, so that was my question. Did I go down the ethics side, which we're not supposed to be, or was it a trick question? So that's my question.
So the question is, could legal find any statute or rule that governed this guy's conduct or lady's conduct?
That was my question.
And it appeared to me that their response was they couldn't.
They said no. Legal said no, but I read it again and again. So
I want to do something different.
I
want
just
to blow
felt,
some steam off.
Maybe I just want to blow some steam off. It bothered me that that you can just say whatever you want to do on Facebook, and you say, well, it's a closed group, and I can say whatever I want to. Did anybody else have a problem?
There's no closed private remarks or groups in the world anymore, in my opinion. I mean, you got. I mean, there should be, but you got to use discretion. Whatever you say, wherever you say it. I don't think the commission needs to make any action on this, but I would hope that the respondent has realized, to be more careful, not only in what he says, but, where he says it or where they say it. I don't know if it's a he or she. And yeah, you just be careful. I mean, do unto others as you would have done unto yourself.
I guess I'm blowing off steam.
Would you want to ask legal why they recommended?
I guess that's where I was coming from. I wanted to know, was there a letter that we could say to send to that person, and is there anything that, or is it just?
Fortunately, no, there's violation. This was done in very poor taste, obviously, and at first blush, when I reviewed this complaint, to me, it was just unacceptable. But after reading the response also, I kind of realized that this, I know that nothing's closed and these groups are, out there on the internet. But at the same time, this individual, the complainant, put up a post that kind of solicited such responses to some extent. Maybe not, they didn't expect them to be so harsh, but the forum that it was in was a in jest. That was the purpose of that particular closed group. So unfortunately, there really isn't anything that the commission can do. I wouldn't even recommend a letter.
No.
I know.
Have probably some more insight into this, but from what has come down from the National Association of Realtors and some policies where they are looking closer to what practitioners do outside of real estate, and if that has any bearing on your status as a license holder. And I don't completely agree with that because, I don't want everything to be such under the magnifying glass where it could jeopardize my livelihood when there was no ill intent meant or any harsh mismeant or anything. It sounded like this was in poor taste, but is it worth, destroying somebody's livelihood? I think that's overstepping in our country of freedoms. And hopefully we just, again, abide by the golden rule, which is, as realtors, the top of the list for all of us.
Okay, Joan, so you've got an answer whether you like it or not. Would you like to make a motion?
So council's recommendation.
I have a motion by Ms. Smith, second by Ms. Torbett, that council's recommendation be adopted and this case be closed. If you're in favor of that motion, please vote aye.
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 If you're opposed, vote no. And the motion passes unanimously. Next up is number 14. I pulled that one because I was confused about who the complainant was or is. And my question to Shalina, which I asked before the meeting, is the complainant your real estate agent or just a buyer or a seller? And
Yes, I have checked. This complainant is a real estate agent.
So it's a real estate agent complaining against another real estate agent.
Correct. Just in the course of a transaction, the allegations were made.
Does that make any difference at all in your recommendation?
I don't believe so.
Recommendation, which was to assess a civil penalty of $1,000 or offer a civil penalty of $1,000 for failure to disclose. What's the term I'm talking about?
Adverse facts.
Adverse facts. And I agree with your recommendation. I just didn't know who I was dealing with, whether it was a member of the public and or a real estate agent. So I like your recommendation. Floor is open to move that council's recommendation be adopted.
So moved.
Mr. Bagley made the motion. Mr. Gwynn seconded the motion. Discussion. If you're in favor of the motion, please vote aye when your name is called. No, we're not doing that anymore. Sorry. If you're in favor of the motion, please vote aye.
Aye.
Those opposed, vote no. And that motion passes unanimously. And finally, 15. I pulled that because 15 references what should have been a court decision May 13th, 2021, and I was just curious to see if that decision had come down. And record, Shalina?
No, it has not.
Would it make a difference? Should we put this one off a little bit, or is it?
If the commission would like to defer this to the next meeting, I'm happy to do so.
Here's when I read through this, here's the line that caught my eye. The buyer threatened to kill the sellers, and the sellers had this on video. The seller also threatened to jab the buyer in the ear with a screwdriver. Now, that's the sentence that caught my attention right there. So do you know what the court case is? Is this like an assault case, or is it related to the real estate?
It's related to the real estate transaction.
Speaking of things you read, Joan, that you...
You just want to know what?
Do you think the court case would be helpful in this, or, I mean, maybe...
From what I recall, I believe that they resolved the issues for the most part related to the transaction. There's no problem in deferring this matter. It's not an aged complaint. It's fairly recent. So
I just wonder if the case is involving the real estate transaction or these assault charges against each other. If it's personal and not real estate, I'm okay with going ahead and getting this closed. That's what I don't know.
I believe it's related to the real estate transaction.
No. Be open to entertain a motion that defers this case for 30 days to see if the court comes down with a decision.
So moved.
Thank you, Ms. I've got a motion by Mr. Diaz, seconded by Mr. Moffitt, that this case be put off for decision until our July meeting. Discussion. All right, then, if you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion has passed, and we'll handle this hopefully, Shalene, in July. Case 20, Jeff.
I actually have reviewed case 20, and I understand the narrative and the council's recommendation. So I move that we accept council's recommendation.
Diaz makes a motion to accept council's recommendation. Ms. Torbett seconds the motion. Is there discussion? If not, then let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed vote no. And that motion passes unanimously. And now number 34. Jeff.
On this one, I'm okay with council's recommendation, but I'd like to add a contract scores to it, not to count for continuing education and to be done within 180 days. So my motion is to accept council's recommendation with the contract scores.
Well, how long? How many hours?
4 hours.
Okay, so Mr. Diaz would like to amend council's recommendation to add a requirement that a 4-hour contract course be completed within 180 days, and to make sure he understands, or she, that the contract course does not apply to any other education requirements.
Excuse me, Commissioner. I'd just like to add, this was a letter of instruction. This is one of Pam Votter's complaints. I believe she's on the line on the telephone. But since this was a letter of instruction, if you are assessing some discipline, such as the education, it would have to be a consent order.
That's what Commissioner was about to chime in there as well. I don't know if you can see me. I can see me. I can't see you all. But yeah, the recommendation was actually for a letter of instruction. So if we're going to actually require them to take some action, we would need to amend that recommendation for a consent order, which can be limited to the educational requirement, I believe. It doesn't have to assess a penalty.
So the motion would have to be.
Correct.
I amend my motion accordingly for it to enter into a consent order to require 4 hours of a contracts course, not to count towards any continuing education, and to be completed within 180 days.
So we're taking the letter of warning instruction. Okay, so the motion, if passed, at this point would only require the respondent to take a 4-hour contract course within the time parameters we've discussed. Is there discussion on that motion, Steve?
No, a second.
Okay. I think I already...
Oh, you already got a second?
Yeah. I think we're good on that. Do you have a second? I think it's Stacy. All right. Let's, if there's no discussion, let's vote. Those in favor of that motion say aye.
Aye.
Those opposed say no. No. The motion passes on a 7-aye vote, 1 no vote. Mr. Ferris votes no. All right, and it's the opinion of the chair that that completes the consent agenda. It's never been done like this before.
Wow.
I don't know what that says, but it might have a lot to do with what the attorneys are figuring out about us. Just a thought. All right, we're on now. Thank you, Shalina. Thank you, Pam. And you ladies right here that I can't see or don't know who you are. Who's sitting next to you, Anna?
This is Caitlin. She is a summer intern that is working with us this summer.
Welcome, Caitlin. Good to see you.
This is Carol McGlynn. She's the paralegal for the real estate program.
You realize the paralegals are the most important part.
Here a minute.
So I want to make sure you understood that. Don't let them tell you otherwise.
Sir.
All right. Good to meet you both.
Nice to meet you.
Thank you. All right, we're on to option to buy. Miss Matlock, tell me something good.
So I'll just also say Mark is on the line, so he might chime in at some point. So the last time I think we spoke, we wanted to have another discussion about option to buy. Previously, it had been the opinion of the legal department that option to buy was not considered activity that is regulated by the commission, as the individual is selling the option and not the real estate. So we looked at this again, and actually Caitlin helped with drafting a memo, and actually we have a court case that just came down by the Court of Appeals in March of 2021. And in that court case, the court held that and if you were promoting an option, that it would be considered licensed activity. So in that instance, when an individual is offering that option, the court believed that the individual that is doing that was acting in place as a broker. So that would give us the kind of opinion on the opposite side of what we normally have stated before. But I would state before, we did not have a case that was exactly on point, but now we do. And that came out a couple of months ago.
Okay, so I'm happy to hear that you guys, I'm happy to hear the court gave you a case to change your mind on. But practically, let's talk about what that means. Okay. So there are flippers, whatever those are. I'm a commercial guy, but a flipper is somebody who gets a house under contract and tries to sell the contract.
That's wholesaling.
That's wholesaling. Okay.
Yes.
So let's talk about wholesaling. Jeff, do you?
Well, yeah, exactly that. Is the scenario is a wholesaler will talk to a homeowner or a person who owns a property and enter into a contract with that owner with an option to buy, and then they turn around and say to somebody else, another buyer, I'm selling you this contract to buy another property. That's the scenario that I understand as wholesaling, and that under before this opinion from the court was a practice that was allowed to go and be not considered unlicensed activity. So,
so is it legal's opinion now that what Jeff just described would be considered unlicensed activity if the wholesaler didn't have a real estate license?
Yes.
That's big news, isn't it? I mean, that's big news.
That's huge.
So that is, I'll just let you know that that is our interpretation of how we read it. So technically another person could challenge us on that interpretation, which has occurred in hearings before. And also we have a court case, so it's been litigated at least at the civil matter. So like moving forward, that is going to be the opinion that we take, but also I wouldn't say that it's like a blanket permission. So we're going to be doing what we've been doing before, is analyzing everything on a case-by-case basis, but you will see probably something a little different moving forward than what we had before, since this is a change from that.
Legal has recommended dismissal of complaints that involve the very topic we're talking about. In the future, is it likely that legal might consider unlicensed activity for the same complaint that a month ago they didn't consider it for?
Dependent on the matter. If it, I don't want to say I never am ever going to tell you. All cases, this is how we're going to decide. But it likely will result in that. July. So moving forward when looking at things, that is going to generally be the point of view that we would advocate for the commission. And as before, it's your ability to accept or reject that point of view.
It's a big deal.
No big deal, because our association right now looking for an.
Right. So we, the commission is able to give informal opinions, but we're not really able to say this is the law of the land. Obviously, if we have questions, sometimes those matters are possibly reviewed and sent up to the Attorney General's office. But I don't think this would be a case that we would do this. But until something tells us otherwise, whether, there's a competing case, and so then you have two different points of views battling, essentially going against each other. But it does not appear that we have that at this time. So moving forward, that's going to most likely be our recommendation.
So this matter was decided at the trial level?
No, it was a Court of Appeals case.
Maxwell, do you have a newsletter that's going to go out soon?
Yes, yeah, I can include it in the newsletter.
Please do.
Yeah.
I'd like to see the court's opinion, the ruling for the court.
Sure. I can send you all a copy of the court case, and we can work on ways to communicate this through the newsletter in other ways through the department, so individuals will know the change from here on out.
So, Anna, one last question. So you've got a Caitlin on either side of you,
Yes.
and you were pretty descriptive on one of those.
Caitlin with the Y and Caitlin with the I.
Well, no, but one was sweet and one was not, or something. So I just want to know if the Caitlin with the Y had anything to do with discovering this case.
Yes, it is Caitlin's discovery.
Oh, Caitlin, good job. Good job. So,
Sweet
Mark,
is synonymous with the name.
pardon me. Yes, redundant, huh? Hey, Mark.
Yes, sir.
So, how come it took an intern to find this case? I'm just kidding. I know, it's good work. We're happy to hear that.
He absolutely,
Go ahead, Mark.
he absolutely did excellent. Caitlin did excellent work on that.
All right, so we're done with this topic.
If you want to be, yes.
Well, I want to get a copy of the.
Yes.
I'll circulate a copy of the opinion, the court opinion to you all. That might be something maybe we circulate otherwise, but I'll give you a copy so you can read it yourself for reference, and it's going to go into a little bit more detail with considering the facts and the underlying matter and how it was applied to our statute.
Caitlin, as far as I'm concerned, this needs to be top line, in my mind, for the newsletter.
Yeah, we have a newsletter planning to go out in June, so we can add it.
Okay.
Okay, we have one option, one item left. This is an opinion request. It's on the iPad, right? Or is it? I haven't looked.
You got a hard copy.
Oh, I have paper.
You got a hard copy. It's right under the agenda.
So this informal opinion request includes three different, or is it just two major questions with subsets to each? And would you, Anna, tell us about informal opinions, what they're worth, how they're not necessarily applicable to everything in the future? What do we need to know before we start talking about this?
Sure. So this will be, I believe, the second informal opinion we've had this year. Typically, so when individuals reach out to us regarding interpretation of rules or statutes, we tell them that we're not permitted to do that because we represent the commission. And ultimately, that decision would be your point of view and how you interpret your own rules and laws. And so an informal opinion is an opportunity for an individual to ask a question that would require interpretation or use of the rules and laws, and see how the commission is to views or applies that information. So informal opinions are in the name, informal. So it's not going to be specific, like it's not the end all be all. It's just essentially an opportunity for you to, if you choose, to provide an interpretation. And the last time that we did do this, we had a discussion on the record, and then a letter was sent to the individual that requested it with a citation to the meeting so they can hear the discussion and a general overview.
So, take any action today. It's not binding.
I don't think it's binding.
Okay. So, do you want to lead the discussion on this as far as what Farrer and Bates is asking? You don't? Okay.
I can lead the discussion in just saying that the commission, you have the informal opinion before you. If you want to take a second to read through it, you can, and it is up to you whether to answer any or all of the questions, and at any point if you have questions for legal counsel, I can provide that.
Okay. So everyone has a paper copy of the letter from Farrer and Bates. It consists of questions. Let's start with the first one. After a commission has been earned by a licensed real estate brokerage firm, can the firm donate an amount of money equal to 1/3 of the commission to one of the firm's preferred charitable organizations? Any quick reaction to that question, Jeff?
Well, the one question I have is as attorneys, words have meaning. So when they say earned, is that equal to being dispersed? In my mind. So they've earned it. It's been dispersed. They've left the closing table.
Right. So after reading this, I would state earned would be the commission that was decided upon during the transaction and what the individual or company would receive. So I don't.
Oh, this is events after they've left the closing table.
Yes.
Okay. My quick reaction is that they could donate a third or any amount that they want to their charitable organization.
I think probably what they're trying to figure out a way is not to pay tax on the full amount. So essentially, to me, from a tax standpoint, what happens is somebody collects $100 and they want to give 30 away, but not pay tax on. So essentially, to me, it's two transactions. It's $100 of income, and then if they want to give $100 to a charity, they go deduct it. But they got to pay. It's income on one side and expense on the other. It's just I don't really understand the reason for the question. I mean,
I don't think this commission can help them on the tax question at all.
Oh, here's another possibility. They may be asking the question, so at closing, because the key word is earned, at closing, can the real estate company tell the title agency to give a third of the company dollar to the United Way, write a check at closing so it never crosses their desk, and then disperse the balance as they typically would? Now, I don't know if that makes a difference as we think about this or not, but that's one way to interpret the question.
My question would be, does it give an advantage to be able to say ahead of time, hey, if I'm your agent and we do this deal, I'd be happy to donate to your charity or a charity that you choose. See what I'm saying? Like, does it seems like it could become some sort of manipulation tool.
I mean, it's almost like asking, can a charity collect a commission? In your scenario, John, it would be if the closing statement says United Way on it, they're not a broker, I don't think.
So we can give our informal opinion on any set of scenarios we want to work with. Joe?
It goes back to a couple months ago. We talked about, could the broker designate other people? Didn't we talk about, could the broker designate the title company to send some checks out? And we found out they could, as long as it was in writing. Is that what we determined a few months ago?
So that is the decision that we heard from the Attorney General a few months ago. But I'm not sure if that is exactly what this question is asking here. I didn't write it, the question, so I kind of viewed it as, at the end of the day, if you have a commission, let's say it's $1,000, is the firm allowed to give some of that money to a charitable organization after it's done? It may be something that is, contracted in the purchase and sale agreement, agency agreement, any of those kinds of things. I think the question is then if that was to enter in the equation with the real estate transaction, if it could be done or not.
Well, my answer would be, after the company dollar reaches the broker, the company can do whatever they want to with proceeds. That's a simple answer.
Yeah, and I think if their object is to, maybe not pay as much in taxes, the fact that they donated the money to whatever charity is going to be evidenced on the closing documents, because the title attorney is going to make a note of it, I would think.
Would they have to if it was after closing? And
I'm not sure.
Closing, why do we? Sorry, if it's after closing, why can't you do whatever you want to with the money that you've earned?
That was kind of what I was thinking. It seems more like a business decision, but I think one of the questions was like what Commissioner Begley was stating before, to see if that action would be permitted. So if it's written in the contract that at this point, this money is to be dispersed to the Red Cross or something, I don't really kind of foresee an issue there, but that's just what I'm thinking.
So the last part, the last clause is they're asking if it's permitted to communicate that's contribution practices to prospective clients. And again, once the money's dispersed and they donate it, they can shout it from the mountain as far as I'm concerned. So
I think it's asking like before the transaction, before they're making a decision whether to hire Jeff Diaz.
Right.
Can you say, oh, a part of your commission, the part of the commission that I own, I have will be sent to Humane Society, something.
We see an example, maybe not a on-point example, but the company like Subaru, when they sell a car, they make a donation to a charity. Now, they may not have the same rules in the statute that we're in jurisdiction of, but that's another example in the marketplace that's out there.
I would think that would be analogous.
Word for us.
Spell that word.
All right, so just to be clear, is there anybody that doesn't think once a company gets its money that it can do whatever it wants to do with it? That I don't think there's heard any objection to that. If we're trying to interpret what the request is asking, it may be asking, can that commission or can that donation to a charitable organization be dispersed at closing and never get to the broker? And I don't know if anybody has thoughts on that. If not, we'll keep moving.
I think, to go to what Commissioner Begley said was, in question of where does the commission go, the broker is responsible for dispersing the commissions unless by agreement other arrangements are made. So
if there's questions about what per statute and rule can licensees do to induce a client to work with them, and I don't know how that applies to here, so there's a question about that. But there's also a question how it's interpreted, that age-old wisdom, to what the left hand, don't let the left hand know what the right hand's doing. Some people do want to say, I'm going to take your money for my services and I'm going to give some of that to somebody. That's some people's style. There's others that will say, I will perform a service and agree to a payment of those services. And they do their charitable giving as a part of their normal mode of operation. But as I read this first question, after a commission has been earned, sure, and give it away.
I guess the reason, I may be wrong, but if you look at this in a large context, are they asking, is this some kind of incentive, like a gift card back type deal? Like, who's going to get the credit for the charitable donation? So the charitable donation so Red Cross gets $500. Is that coming from the brokerage firm or from the buyer? Because you're saying that you're going to make this donation and the buyer's request to where it goes. So is it going to say this is a $500 donation from Joe Begley because he bought a house from me? Or is this going to be just the firm? Who gets that tax? What he was talking about, when it comes tax time, who gets the credit for that donation? I'm not asking them for tax reasons, but I'm saying throwing that back into our thing about, can you incentivize with advertisements that you're going to make, you're going to give $500 back? Or do you see what I'm saying? Am I way out of bounds?
I think from a consumer protection perspective, I think as long as there's disclosure by the broker that we're going to earn this commission and part of it is going to go to a charity of our choosing, and here are the charities that we donate to. I don't know if you need to go that far, but as long as the consumer is aware and consents.
I just don't think it could be in their name.
Right.
It could be like in honor of, but I don't think it could count as their donation.
Whose donation does?
Whoever donates. So if the firm donates,
the
it's the
firm
firm.
would donate it.
Because it's the firm's money at that point.
So the firm could donate it and, you know, joke.
Points.
That's why they're asking the question. I think the question is, I think they're trying to get at gift. I mean, am I way off base, Anna? You think they're kind of getting at the gifting thing? Like, can I give a for you to do business? Maybe gives me.
I don't really see it as an incentive. I see it as possibly a firm making that decision with that's just how they do their business, is that if you decide to join my firm, if you hire us for work, this amount of the commission will go to a charitable organization. So I don't really kind of see it as kind of like an inducement. It's just, I see it as this is an option. But I'm not really also, I guess I would leave that decision to you all to make. If
it's not an inducement, why do I tell anybody? Why don't just after I get the commission, I make the donation? Why would, if it's not an inducement, why do I need to tell them beforehand, hey,
Right.
listen, if you come do this with me, this is what's going to happen. It's an inducement. Now, whether it's an inducement of, actually that person getting that benefit, but it's definitely throws, if you've got 10 businesses that aren't doing it and you say, well, I'm going to step out here and throw this up against the wall and see how it works.
Well, and
it is,
the skeptic in me and the cynic in me would say it's not an inducement so long as the consumer doesn't derive the benefit. If it's money that the firm is donating to a charity, I don't think the consumer at that point is involved because they're out, the transaction's over. They've gotten their disbursement, they go their way, the parties go their separate way. The one concern I do have is, does the buyer work for the charitable organization that's receiving the donation? I think that would be a questionable transaction at my point, at that point for me.
Where I feel the second one may come into play. Sorry. If they already have a list, so if the firm already has a list of charitable organizations, I think that would take away that option of if the buyer was a beneficiary of that. I see what you're saying. I mean, so many ways it's unethical, but it's worst case scenario.
I guess that's the case by case basis we have to deal with.
I think the situation's muddying the water. To me, this is two transactions. It's a decision to make a contribution to a charity, and it's a decision for the owner of the home to pay a commission to somebody. Now, if I were the homeowner, I would say, okay, why are you doing this? In other words, are you charging me too much? I mean, why am I paying this if you're going to give a third of it away? So maybe my fee is, maybe you're charging me too much. Or possibly, what if I don't like the charity that you want to give the money to? So now you've got the homeowner kind of in a deal with, is this somebody I want to hire? I just think it's complicating people's lives to bring a charity into a closing of a transaction. After it's closed, he gets the money or she gets the money. You give 100% of it away to whoever they want to.
What would be the motivation to bring it into the closing? Honestly, why not just do what you want with it after you've earned it?
I think it's got to be it's a PR, probably some kind of a PR move. This is speculation. Some kind of a PR move, and they're trying to say we're giving to charity. We're giving a third of our commissions away to XYZ, and it's a marketing ploy, but it's
in the current political climate,
clean.
I think it would be crazy because you could get extremes of, I'm not going to going to do business with somebody that's going to donate to these liberal causes.
Right,
I'm not going to
exactly.
do business with the conservative causes. So, in my opinion, you'd be shooting yourself in the foot probably, because you're going to eliminate buyers from one end of the political spectrum or the other. Even with the Humane Society, honestly, I mean, it would be hard to find an apolitical nonprofit.
I do. The question that Commissioner Gwen has posed kind of really goes back to the subject of the question. Say it's a marketing ploy. Say it's not. The question I feel like is asking, is that marketing ploy or the action permitted under our rules and statutes? Or do you see a potential violation? So, marketing ploy or not, the question is whether making that donation is going against our rules and statutes.
So, if somebody says to me, we're going to give a third of the commission away, I'm going to ask them to cut their commission by a third. Okay. Let me make my own decision on who it goes to.
Right.
That's not speaking to the question necessarily.
That's the marketplace, though.
Yes. So the question to me is, maybe, can a real estate broker have a title company direct some of the broker's funds to a nonprofit so that the broker never has to handle it, but the nonprofit gets the benefit? I mean, that's one way to think that's what this question is about. Now, we know that a broker can tell a title company that the title company can pay its agent directly. That's what Joe was talking about. But can we also tell the title company to take some of our funds and ship it off to East recipients?
I would say no.
Okay. There's no right or wrong answer today. They're looking for an informal opinion, and if we don't have a consensus, we just have some people say yes and some that say no. But I like your answer myself.
I think, though, the agent should be disclosing in a commission agreement. So the commission agreement should control what happens to the commission. So if I was an agent wanting to do this, I would go to the homeowner and say, okay, here's what I'm going to do. I'm going to put it in writing. I'm going to charge you 6%, and at closing, 3% of it, or whatever the number is going to go to this charity. And either they sign it or they don't sign it. And if they sign the agreement, then they're agreeing to it. They meaning the homeowner. They're the ones that are paying the commission.
If you are doing that as a marketing ploy.
Yeah. Yes.
Yeah.
Or as a business practice, however you feel about it. Maybe.
Well, if I'm doing it just as, if I'm passionate about a certain charitable organization and I'm going to do a good business, I want to build my business, and I'm going to do that, I'm going to make my money, sell the homes, represent my clients, provide all the skill and care, get my commission, and do what I want to do with it. I don't have to disclose where I send it. But if I'm saying, if I'm marketing, if I'm putting it out there, work with DJ Ferris Realty, a third of your commission will go here, then I do have to have that in the agreement.
Right.
I guess. But
if you're asking the title company to wire money to somebody at the closing, that's not in the commission agreement.
Well, that's putting in here.
That's a separate deal. That's not part of the real estate closing.
Right, but I don't know if that's what they're asking here.
I
really.
think the question is too unclear to figure out if that's what they're asking.
Because the statute says, talking about gifts and prizes, this is neither a gift nor a prize, but in the statute it says a licensee may offer a gift, prize, or other valuable consideration. This speaks to if there would be some valuable consideration. Like Jeff mentioned, if this person was on a board of a charitable organization, that gets a little muddy. But is it valuable consideration? If a person gets a good feeling by working with you, is that valuable consideration? I don't know. I'm not. We're muddying the waters, I think.
I think the easiest thing is to just pay out the commissions, and then everybody does with their money what they want to do.
And if you want to say afterwards that that's what you did with the commission, I feel like that's your right to say that, and that wouldn't fall under anything that we would have authority over because it's your money at that point.
And I'll say that you will rarely get in a tight spot if we follow that adage across the real estate practice: disclose, disclose, disclose.
I'm not going to say this is analogous. Is that the word? Okay.
Good job.
However,
That means similar.
let's just say that someone has a tax lien, and many real estate companies have a tax lien on them because they haven't paid their federal taxes. And so the Treasury Department or the IRS comes to the broker and says, we want you to withhold so much out of every paycheck he gets. I don't think they go to the title company and say, we want you to hold it. It's the broker. So like I said, I don't know that it's analogous, but it's going to reduce that commission, but it's going to reduce the agent's commission, not necessarily the company dollar. But I think my feeling is all these ancillary deals probably should take place inside the broker's office, because the broker is the one who's the check is made to. They divide it up with the agent, they divide it up with the IRS, they divide it up with accounts receivable, they divide it up. And I don't think trying to push that off on a title company, my sense is probably the right way to do it. Just me. Also my opinion that we're not going to have a unanimous opinion here to offer to ferret and base it, even if it is informal. It's a topic we've discussed, and I think we can move on to the next one unless there's some reason. Number 2 is a violation of any statute or TREC rule for a licensed real estate brokerage firm to act as a facilitator in a transaction in which the buyer and seller do not want to be represented by a licensed real estate agent for 1% of the total price. Percentages, 1% or 2% or 1.35% are not relevant to the conversation. But can a broker collect a fee for just putting a deal together? I mean, I think that's what this question says.
Yes.
Yes.
And I think we might be able to give an opinion on this one.
Yes.
Anybody disagree with the fact that if you can make that deal, you can get paid? A lot of times it happens, especially in commercial real estate and others as well, where somebody's expertise is needed just to get the paperwork done.
Negotiate a fee and get it, and they can use it in the market for prospective clients. Yeah,
okay, and then a subsection of that question on the top of the second page. Does it matter if the buyer or seller or both parties pays the firm the 1% fee?
I think that can be governed by agreement.
Yep.
So whatever the contract says.
Disagree with that? We don't care who pays it as long as everybody knows who's paying it. And if you're double dipping, both parties need to know.
Yeah, disclose. If you're a facilitator, you're disclosing you are not representing either party. It's all in writing. It's all disclosed, and the consumers are aware.
Finally, there's based on statute or TREC rules, can the firm communicate this 1%, let's say, facilitator service offering to prospective customers? Would it be a violation for a company to advertise, we don't need to list your property or sell it, but we'll help you put the deal together for 8%?
No, as long as all the terms are disclosed, in my mind, that's fine.
You okay with that?
Yeah, I'm okay with that.
I'm okay with it. Are you okay with that?
Okay with that.
These are not, whatever we decide today or don't decide today means nothing in the future, but at today's meeting on this question, I think we agree that certainly if that's the business model the firm has and they want to advertise it, there's nothing to keep them from doing it.
In many cases, it's what the marketplace has demanded. Is there kind of a strong word, but I've had closings where clients call and say, hey, we know we're going to list our home, but we've spoken with a friend who has known our home for 20 years. They want to sell it. We'd like to remain friends after this. Would you be willing to help us put that deal together? And I'd say absolutely. And then we enter a discussion on what that fair compensation is. As we all know, nothing's ever set. And so, yep.
All right, any other comments on that? The chair is going to opine that we're done with this discussion.
Well, hold on, Mr. Chairman. There's something that I wanted to bring up.
Okay.
And it goes to your pet peeve about billboards. This morning, a number of us, when we got our valet tickets, there was a QR code that you could use to call for your car at the valet. And it occurs to me that, there's a lot of those in the marketplace now where you have a QR code to get more information. So I think those billboards where agents are advertising, I will buy your home if I can't sell it or something like that. The big hang up about those is disclosing all the terms. And you can't really do that on a billboard. But in compliance with the one-click rule for websites, if they can add a QR code to their billboard that can be scanned and used by the consumer that discloses all the terms of the I'll buy your home circumstances, does that, in your mind, allow for the billboard to be acceptable under our advertising rules?
Do a QR code.
I was going to say, can you get a QR code off a billboard?
Well, ability is the question, but I was just wondering if such a thing were possible, would that satisfy?
Well, the statute is pretty clear on billboards.
Okay.
But I don't know. But the rule about incentivizing people or offering gifts or prizes is a rule, not a statute. Is that right, Caitlin?
Sorry, say that again.
Well, there's a statute about your company phone number and the size and that kind of thing. But the rules on
specifics are in.
If we don't sell your home, we'll buy it, kind of deal. Our rules state that on that billboard or whatever advertising medium they use, all terms and conditions have to be listed.
Yes, the majority of the specifics of the advertising rules are in rule. Advertising rules in rule. I don't know if I feel comfortable recommending people drive by.
Well, again, I'm not speaking to the wisdom of it. I'm just saying, for purposes of advertising and complying with the rules, is that something that would satisfy?
I think the one-click rule was intended for social media. It's under the one-click rule is under the social media advertising.
Could you have the QR?
So business cards still wouldn't be social media. It would be. They didn't. I think the rule. Let me pull it up. But I think it specifies social media advertising is like Facebook, Instagram, etc.
Could you have a QR code on your business card?
Business cards, for example.
Well, business cards are not under the advertising rules.
I don't want to.
It's a fair question.
Keep everybody here, but
yeah, I don't think that applies yet to non-social media advertising.
I'll put that down as an informal opinion from the executive director. All right, Caitlin, anything else?
Nothing else. Thank you.
Anna, 1 day or 2 days next month?
I don't know.
Answer.
When
you do, you'll let us know.
Yes.
Okay.
Right. We're almost 31 days out.
I think it will be 1 day, barring something that I don't know about happening.
So, did we do some an emergency suspension, for instance? Is that going to show up here at some point? And shouldn't that happen in a timely fashion? Okay. I'm not suggesting it's not, but I see that on fairly short-term horizon, I would think. And that won't be a special meeting; it'll be a second-day meeting. Okay. All right, Shalina, push that button for us, please.
One last thing, Commissioners. It's with great sadness that I am announcing that I am leaving the department and joining the Board of Professional Responsibility at the end of the month. So I just wanted to.
What does that board do? It can't be nearly.
We regulate attorneys, so be closer to home, and I'll be regulating my own. So I just wanted to say I appreciate the opportunity to work with all of you. It's been a sincere pleasure, and thank you.
Thank you.
You did a great job for us, and you put up with people like the chair who don't half the time know what they're talking about. We appreciate your patience into that. Thanks.
Thank you. You did a good job.
Great.
All right, commissioners, let's go around the horn, see if anybody has any remarks they want to make before they leave the building. Steve?
Good.
DJ?
Thank you. I'm good.
John?
I'm just glad we get to meet together in person.
Joan, nice to have you here in the building, the Davy Crockett building.
Glad to be here.
Joe? Jeff? Stacy? So I want all of you to be glad that Caitlin and the staff with Tennessee Real Estate Commission are doing such a great job. You don't have anything to talk about in public. In years past, we've had a litany of things we'd have to go over. It's smooth, smooth, smooth. Keep it up. Good job. Thank you all. Have a safe trip home.
Amanda, let me talk to you just a second.
Put it on my list.
Ugh. It's brutal. It's kind of brutal, but it's got a lot of historical information. Like founders are thinking.
Beach.
Going to the beach.
Not
All right,
going
you
to
too.
what?
See you next month.
Thank you, everybody.
Well done.
See you next month. Good to see you.
You too. Safe
See you next
travels.
month. Good to see you.
You're going to see you.
I'll see you in Texas.
Caitlin?
We got the.
Yeah, man, we're going to be heading to San Antonio.
Yes, we are.
Man, that is super.
We gotta find it.
We'll find it. We'll find a couple of them.
You're muted. You can press *6 anytime to unmute yourself.
You got it, man. You got
I
it.
don't have the red book or that little. I do have the folder.
Who's sitting here?
Me.
You. Wait.
Doesn't work.
Oh, yeah. This isn't actually her book.
Let's go now.
She just put a name on it. I mean, you could.
Anything on there?